All right, let's go through this one now. You'll notice this is all the same as the other ones. This is my memorandum and notice revocation of jurisdiction. So notice of revocation of plaintiff's grant of jurisdiction comes now. It gives legal notice to all parties of my revocation of consent to grant jurisdiction. Plaintiff gives notice that he both claims and is in possession of a right to estoppel. Okay, this is important, man. This is how you stop these people. Okay, you might want to look into estoppel, notices of estoppel, certificates of estoppel. To the claim of the Third District Court, they or the Court of Equity, which is your child support, family law court. That's what they want. They just want money. They want equity. That they could, in effect, fairly and justly adjudicate the litigation sought against me by the petitioner, my ex-wife, in the case number from '06, and here's the divorce decree number. The claim of the court in the decree came in the form of a document that was not presented to him for his signature, in which the court promoted and entered its ability to fairly and justly resolve the case of the petitioner against me, the plaintiff. Unbeknownst to the plaintiff, the documents entered as a default certificate, if you remember that. If not, look back. It's one of those big ones about affidavits of service and others. Several of his constitutional rights were being then waived, and had he been aware of the loss of these rights, he would have never agreed to signing the birth certificate, the marriage license, or any documents to let the case be heard in that court, which is the family court in front of the commissioner. And I don't consent, and I never did. Okay, so there's Miranda again. There's Brady versus U.S. Waivers of constitutional rights. Not only must they be voluntary, but they must be knowingly intelligent acts done with sufficient awareness. Okay? Party cannot be bound to a contract he has not made or authorized. Okay? Free consent is indispensable. Okay. Now the other thing I want to show you too is I am numbering my paragraphs. Okay? This one all has to do with the same thing. So the plaintiff, since the date of his birth, has continually refused to yield so much of one of his constitutionally guaranteed rights, including the resolution of the divorce case presently before the court. Plaintiff gives notice that he has never dealt with the family court system or any court of equity to his knowledge previous, and claims an affirmative defense alleging that he did have a misleading representation asserted by this mentioned court, and that he now has an injury and a detrimental change in his position directly resulting from that said impropriety. Okay? I hope that makes sense. After securing documents, in other words, I went to the court and I got all the documents and I presented that after securing the documents that were presented and entered in the case by the court against the plaintiff, I was the defendant in the divorce, upon which he had faith and relied upon to my detriment. The commissioner and judge giving jurisdiction to this court without his signature was deceitful in nature in that they made no mention or reference to my constitutional rights whatsoever, that they were to be forfeited, such as the right to a trial by jury, okay, and freedom from involuntary servitude, and the right to be free from incarceration for failure to pay a debt. Now this is where it gets a little cool. Okay, like I said, when I talked to this dude, he went to paralegal school, and lawyers and attorneys, when they go to the bar, what they're taught how to do in law school is win an argument. Okay, they're not taught the Constitution. They spend very little time. What they're into is administrative procedures, contract law, the UCC, all that stuff. Okay, so the practice of incarcerating somebody for a debt in civil matters was banned by the Constitution, interpreted by the Supreme Court in 1983, ruling that incarcerating indigent debtors was unconstitutional, okay, under the 14th Amendment. The plaintiff, as well as all citizens, have a constitutional right to be voluntarily indigent. So what is indigent? Well, that means you have the right to be a freaking bum if you want to be a bum, okay? And further, plaintiff has no bill or no debt with the state for the reimbursement of welfare. And the state did then illegally lend its credit to the petitioner, which would be my ex-wife, in the divorce against him, using its far superior power and resources to collect on behalf of one citizen against another, which thing is blatantly illegal. And we're going to go into how it's illegal here now. Neither the state nor the federal government have any legal authority to collect money not owed to them on behalf of one citizen to the detriment of another. Okay? On the contrary, both the state and federal governments do have an obligation to treat all citizens uniformly across all classes. Okay? And this is what me and that dude talked about, and he said this was the gold mine right here. These people, when they start doing your child support and they show that you're making more money than her or she's making more money than you, but you have to pay child support, and they're treating the two of you differently, okay? They're making her a custodial, they're making him a non-custodial, or however it goes. And in my paperwork, it shows very clearly that I was making 58% of the money and she was making 42%. And therefore, they started doing all of their child support calculations off of my income and not our income. So they're treating me differently. Okay, but we'll get into this a little bit. It gets pretty cool here. So therefore, the plaintiff comes now and gives notice to all parties that in accordance with Utah Rules of Ethics and the Professional Conduct 1.2, this court must promote confidence. Okay? And what is rule number 1.2? It's promoting confidence in the judiciary. A judge should act at all times in a manner that promotes and shall not undermine public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Okay? The plaintiff has a right, and he does now withdraw all previous agreements with all parties to this litigation because of substantial impropriety. This includes his obedience and adherence to all orders issued to date from this court and all orders referenced in the decree of divorce that was adjudged in 2006 by Michelle Tack, signed by Mark Korus, and enforced by the ORS. Okay? This unlawfulness gives the plaintiff the legal right to disobey the orders of this court that offend the conscience, that he believes strip him of his constitutional rights and thrust upon him civil disabilities. Okay? When you're treating me differently, okay, that's just like they can't not give you a job because of race, creed, color, religion. That's what that is right there. That's a civil disability he would not otherwise have to endure. Okay? This rule and others also empower the plaintiff to withdraw his consent, obedience, and submission to jurisdiction by any family court or court of equity, which he would lose even so much as one of his constitutional rights until such time suit continues under jurisdiction of a court wherein no civil disabilities exist. Okay? The plaintiff will make reference to the plain meaning rule, to which all state, statute, rule, and law are subject. Okay? In other words, you can't be using all that legalese. Okay? The plaintiff asserts the claim that adjudication under the jurisdiction of that court stripped him of his right to a trial by jury and also strips him of the right to be subject to the plain meaning of the laws of the land. What's the law of the land, people? Okay? That's common law. That's the Constitution. It is the assertion of the plaintiff that no jury, upon reading the Constitution of the United States, can come to any other conclusion except every United States citizen has the right to a trial by jury in every matter exceeding $20, right? We all know that. Has a God-given possession of the right to be unemployed if I want. If I don't have to work, if I don't want to work, man, I don't have to work, fool. Since every citizen has the right to be free from involuntary servitude. Okay? There's United States versus Kaminsky. For the purpose of criminal prosecution, the term involuntary servitude necessarily means a condition of servitude in which the victim is forced to work for the defendant by the use of threat or physical restraint or physical injury, by the use of threat or coercion through law or the legal process, not the lawful process, the legal process. This definition encompasses cases in which the defendant holds the victim in servitude by placing him or her in fear of such physical restraint or injury or legal coercion. Okay? Therefore, while being indigent, plaintiff has the right to be free from any and every civil debt owed to fellow citizens without fear of incarceration, howbeit suffering other consequence by choice. So if I have the right to be a bum, okay, we're going to get into that too. Yet this court seeks to force the plaintiff to be constantly employed so that he can be garnished, having his money taken by the state for public purposes without compensation, which thing is also blatantly unconstitutional. See the Constitution Amendment 5. Okay? Additionally, money is property, and the state will continue to take it even after the alleged debt to the state is paid in full, thus lending credit to the petitioner by granting her free, uncompetitively priced legal collection services. Now, this is where I wanted to stop. And I looked this up. In the state of Utah, if you are going to be a debt collector and have a business, okay, you have to go down to the Department of Commerce and file and doing business as and do all that stuff. You have to have a license and all that. Well, guess what? The state of Utah doesn't have to do that. They can collect debts with their Office of State Debt Collection, and they don't even follow their own fucking rules, man. Okay? Because the Office of State Debt Collection is a debt collection service. It's a state debt collection office, agency, whatever. But of course, they're not registered with the state and they're not doing business as and none of that shit. Okay. So what they're doing is giving their services and using the full force of the state and all their attorney generals and all their attorneys and all their legislation and everybody, the whole state is ganged up on you to collect this $200 a month for somebody else so that they can make a $25 fee. Okay? That's basically what that says. Okay? As it stands today, the state, having been assigned the right to collect a debt, which I didn't give them, but she goes in there, and this is part of that debt collection. Okay? This is part of her signing away her rights in order to get child support. Okay? As it stands today, the state, having been assigned a right, lacks the legal basis to use any means greater than granted one citizen to litigate against another to collect the same debt. Citing the above paragraph, we know that one citizen completely lacks the legal basis to incarcerate another person, right? So I just can't walk down the apartment and go down to, number 2 and say, hey, dude, you parked in my spot. You're going to jail, right? Well, it's the same thing with the state. Therefore, should the state be assigned the right to collect a debt owed by one citizen to another and did incarcerate any citizen for failure to reimburse another citizen, that state would be lending credit to do so by reason that the state would be granting to the petitioner a power she did not previously possess to use to the detriment of another citizen, which thing is unconstitutional in the state of Utah and probably all over. A creditor cannot assign a right he does not possess. Therefore, if the state incarcerates an individual for not paying this alleged debt, it has added a right and a power that was not previously available to the citizen, which could only be explained by the state lending its credit to the detriment of the civil rights of the citizen in that case. The plaintiff now gives notice to the court that the state of Utah, that Article 6, Paragraph 2 of the Constitution states that the Constitution is the supreme law of the land, and reminds all officers, okay, that they took an oath. This Constitution shall be the law of the land, blah, blah, blah. We all know what this is. Okay, we'll stop it here real quick. Okay. All officers of the court are sworn to an oath. Okay. And the state does this in spite of the fact that the happily married yet unemployed father and husband, who's a slumberjack that's laying on the couch playing Xbox, of a woman having never denounced him, and living on public assistance, is not bothered by the state to get a job and pay reimbursement, thus violating the plaintiff's constitutionally protected rights to be treated uniformly across classes. I hope that makes sense. Plaintiff gives notice that it is illegal for any citizen to be treated as a commodity. In that state is selling the forced performance of a citizen to the federal government for money. And that's just a fancy way of saying they're getting federal funding for enforcing child support and making up these invisible contracts and these schemes and these creating systems and all that stuff. So further, the act of this court to present the plaintiff with a document to sign giving jurisdiction to a tribunal to adjudicate the case in exchange for the yielding of a constitutional right in favor of one citizen against another is a violation of the law. State against its own citizen. Okay? So you're giving me paperwork and telling me I have to fill this shit out, right? And you don't mention in there, oh, by the way, when you sign this piece of paper, we're going to dog fuck you and take all of your constitutional rights, and you don't get a trial by jury, and we can trespass and stomp a mud hole in your ass because you signed this document. The state has a duty to provide an impartial tribunal, and the act before the fact to disregard important civil rights to one citizen against another, except impartial, and is in effect of a partial tribunal, partial towards the state, harvesting income from citizens and thus violating due process of the plaintiff. The process clause is supposed to ensure laws and the process are applied in a way that protects and preserves a plaintiff's rights. Ideally, okay, they should work together to provide all people under the state and federal with the same level of protection, which it doesn't. Okay, which is age, race, class, creed, color, you know, all that, obligor, obligee, non-custodial, custodial, okay, so they violate it right there. The Fifth Amendment, okay, life, liberty, or property. The 14th, okay, and here's Amendment 5, here's Amendment 14. Therefore, the plaintiff has a right to rescind his consent to submit to the jurisdiction of the above mentioned and has done so. Any presumptions of personal jurisdiction entered by any clerk, commissioner, or judge without due process and consent are hereby void and without legal force. So, there you go. And that is a memorandum and notice, and we'll see what happens. Okay, peace.